afternoon and good evening, everyone. I am Jayashree Mitra, but call me Jay. Big thank you to the organizers for having me here today. It's a pleasure and an honor. Just a couple of housekeeping things. Please feel free to interrupt me at any time with questions you may have. The firm legal counsel insists that I say in the beginning that this is for informational purposes only. It's not legal advice. We'd have to have an engagement letter in place. And I hope this is going to be a very interactive and interesting conversation for all the participants. So what are we going to discuss today? Patents and psychedelics. I'd like to talk a little bit about my background before we launch into that, because I think my history does play a role in how I approach the subject matter. I started life as a bioscientist researching the effect of cocaine on developing brains in rats. It was fascinating because the plasticity of the human brain is very interesting, and how it continues to evolve through the life of the individual and how it reacts to psychoactive substances. Things happened and I had to figure out a new career track. So I became a lawyer. And for over 10 years, I've been working as a patent litigator mainly, but also doing antitrust work related to the pharmaceutical industry, helping clients build patent portfolios, advising on other IP issues, and generally being linked to how the pharmaceutical industry works. And I've seen practically every aspect of it, from drug development at the startup stage to how a mega pharmaceutical company works and its global footprint and all the nuances that come into play in having a very successful drug establish market domination across many countries across the world. I got into what I would call the Schedule I practice area when I started working at my current law firm of Zuber Lawler. I'm in the New York office and I'm a partner there. The firm had a robust practice in cannabis, and the clients wanted to know how to protect their IP. And that was fascinating because the great thing about patents is that the fact that something is Schedule I doesn't stop us from getting patents on it. But just getting a patent and spending a lot of money on it doesn't make sense unless there is a rationale for it and there is a strategic viewpoint for it. And that is what also guides the thinking when we are talking about psychedelics and patents, because psychedelics are also Class 1 substances. And when I'm talking to clients in the psychedelic industry and they're talking about building their IP portfolio, the questions we have to ask: can we get a patent? Yes, you can get a patent, because if it is patentable subject matter, that is it not obvious? Is this something new? Can we make the case that despite some of the compounds being known for thousands of years, certain aspects of the technology being known in traditional medicine, is there something that you have discovered, that you have found in the course of your research? Is this something that is non-obvious, that is novel, that we can craft claims around? Can we patent it? Yes, we can. Or at least we can present our case to the USPTO and file the application. But then the next question is, what is your path forward? What is it that you're trying to gain as a company by filing not just this application, which is really just the start of your journey? Because what you want to do with this first step is envision where you're going to be in 10 years, 20 years, because this should be the beginning of a family of patents. 1 country, 10 countries, 20 countries, 1 disease, 10 diseases, a family of patents, more than 1 compound, more than 1 method of treatment. What is it that you're thinking about achieving by embarking in the journey of patenting your product? Or what is it that you're thinking of for your company? And every industry has its own rhythm. So for example, in cannabis, when we are talking about patents, You're talking about packaged goods, you're talking about cosmetics, you're talking about extraction, extraction patterns where the product that's being extracted could be used in many different products. But in psychedelics, where there is a more of a long-term play at issue, approaching portfolio building, how do you tie that in with your regulatory strategy? How do you tie that in with the Schedule 1 status in the United States versus its status in other countries? So all of these factors come into play when we are talking about patenting psychedelics. And there is, of course, the question of its historic nature and the fact that there is a lot of prior art out there, and that gets in the way of how we think about the strategy of patenting the new developments that the client is contemplating. So that's kind of the baseline where we start from when we are talking to clients about where are you going with your patent portfolio, rather than just rushing in and saying, yes, let's just file a patent tomorrow. Let's file a provisional application tomorrow because that's the one-shot deal we are going to take and we are done with it. Then and then what else are we seeing in the industry? Many companies are filing applications because there is a gold rush. This is a new industry, and those who get in first are going to have the advantage because there is a lot of ground to cover and there is relatively little competition at this point. Now, there are those who believe that perhaps patenting is not the right way to go, and perhaps the way to work in this industry is to work cooperatively and the knowledge should be public. Well, that is certainly a way to look at it. And if they want to share the knowledge and put it in the public domain, that's also a very that's an acceptable way of looking at things. And there are those who are doing it, and I would say they deserve a lot of respect. But also, if somebody wants to find a way of building their patent portfolio and monetizing it, I think that's also a credible way of moving the industry forward. It's just, what is it that works for you? That's really the issue. And how are you crafting your applications? How are you presenting it to the USPTO? And ultimately, what are the claims that you're going to be able to get? Now, the other interesting issue that developed this year was that we've already seen our first adversarial proceeding. This is a very young industry. We've just started filing patent applications here. But earlier this year, Compass Health, which has a patent on psilocybin, actually the patent is just generally, I'm not going to go through the claims, I don't even remember all the claims, but generally it related to the polymorphic forms of psilocybin, and polymorphic forms, very generally, again, it's the crystalline forms. How do you make different crystalline forms? The patent was issued in 2019, I believe, and the validity of the patent was challenged before the what's called the PTAB, Patent Trial and Appeals Board, in a proceeding called the IPR proceedings. IPR proceedings are a kind of adversarial proceedings we have in the United States where anyone can challenge the validity of a patent. And it was challenged by a law firm called Cohn Law and Associates, and the funders were not disclosed initially, though I believe a corporate entity was ultimately formed. The patent office has the discretion not to institute trial, and I believe in this instance it didn't, because for various reasons it explained in its decision. But what's interesting here is that we've seen the first adversarial petition to invalidate a patent filed at a very early stage by an entity that doesn't seem to have an interest in the patent. For example, it's not a rival pharmaceutical company. It's just a law firm. And who is funding it is not even clear. So it's clear that there is value to patenting in the psychedelic industry. Companies individuals, I believe. I mean, there's a lag time of 18 months. We don't even know how many patents have been filed in the interim. But clearly, people are rushing in to file applications, get their foot in the door, mark their priority date. And I think in a few months, as more and more applications get published, we are likely to start seeing just who has gotten their foot in the door and stake their positions. And the psychedelic industry will likely over the course of the next year or so have to take stock as to how much of the intellectual property has been grabbed in this gold rush. So the message that I would give is that patents in the psychedelic industry certainly attracting a lot of attention. We've had a wave of filings if public announcements are to go by. But from a strategic point of view, if I were to give my 2 cents, it would be think about what is it that you're doing with your applications. Is this the beginning? Is this a long-term strategy? Where are you going with your company? And also be prepared to face very early adversarial proceedings because as the Compass Health proceedings show, adversaries are there and they're willing to challenge it very early. And getting a patent is expensive enough. Defending it is much, much worse. I have been speaking without it. So I think I'm going to pause for a bit and ask those in the audience if they have questions for me.
Can you hear me? Oh, I don't. Hi, Jay. This is Deborah. Thanks so much for joining us. If I could ask you, do you think companies that are setting these patents up are in for lawsuits and just facing a potential war legally?
I think it depends on the perceived value because it's expensive to fight a patent as well. If somebody's bringing an action, their bill is not trivial. So when you file a patent, it takes a while to get it. And then when somebody files a challenge, it's also an expensive proposition. So I think what we saw in Compass Health, I mean, there was somebody clearly perceived a value somewhere. Because if you're dropping potentially a six-figure sum, challenging a patent, there has to be one would presume there's a rationale for it. So the answer to your question is, I think what we are seeing are certain signs, but the math, the economics behind it, I think we'll have to get more data before we can answer. What I would take away from the whole few months of, between when the filing was made and when the PTAB decided not to institute the trial and basically brought the whole saga to an end, is that early filers certainly have an advantage in that they are likely to get patents which would be of greater value in the sense they are in uncharted territory and probably face less challenge from prior art. But if they have the valuable patents that others in the industry covet, there is a probability that they're likely to face early challenges too. And this was one incident, but who knows how many more we'll see.
Yeah, we're definitely in new uncharted territories, and I think, obviously there's going to be a lot happening and a lot of change to see. But thank you so much, Jay, for joining us from Zuber Law. We really appreciate your input and knowledge